So let's imagine it's 10 o'clock in Washington, D.C. The audience is seated in the courtroom, the justices are seated on the bench, and the first case has been called. What's going to happen now? Well, for every case, it's the petitioner who goes first. The petitioner is also sometimes called the appellant, but in this lecture we'll refer to them as the petitioner. The petitioner is the litigant who lost the case in the court below, and they are called the petitioner because they are the party that petitioned the Supreme Court and asked the court to review the case. Of course, the petitioner is hoping that the Supreme Court will reverse the lower court case. The respondent is the other side who won the case in the court below. How do you know who the petitioner is? Well, the petitioner is the litigant who's named first in the case name. So a name of a case can actually change as it works its way through the legal system, but in any case it makes its way through the Supreme Court. The litigant that's named first lost the lower court decision and is seeking review. So for example, in the case of Bowers v. Hardwick, Bowers would be the petitioner and Hardwick would be the respondent. And of course, Bowers would go first in oral argument. So, when 10 o'clock rolls around, the first case is called. The lawyer for the petitioner approaches the lectern, faces the court, and says, "Mr. Chief Justice, and may it please the court." And with those magic words, the clock starts ticking. And in fact, there is a series of lights at the lectern to let the attorneys know when their time is drawing to an end and when it actually does end. Now, the 30 minutes are strictly enforced, but the petitioner has the option of saving 10 of their 30 minutes for rebuttal. And so they'll speak for either 20 or 30 minutes. And then the respondent goes next, and they will speak for 30 minutes. The only difference between the petitioner and the respondent, other than the order in which they speak, is the fact that the petitioner does not have an opportunity to rebut. They have to use their entire 30 minutes all at once. And then if the petitioner has saved their 10 minutes, they get to go again, of course, after the respondent does. So, as you'll notice, the petitioning attorney and the respondent attorney never actually speak to each other. They never engage with each other. Rather, they engage with the justices, who ask them questions, questions, questions. An attorney preparing for oral argument at the Supreme Court would do themselves no good by simply preparing a 30-minute speech, because attorneys never get an opportunity to go very far into their arguments before they're interrupted with questions by the justices. The justices can interrupt you for questions at any time, and they can do it for any reason. And this questioning comes out of your 30 minutes. The clock does not stop just because the justices are asking you questions, and sometimes these questions can be rather lengthy. And in fact, sometimes the justices will talk to each other. They'll engage in a dialogue, and the time is quickly draining away, and the attorney's just sitting there not saying anything. And the questions may or may not pertain to what you're talking about. If you're an attorney arguing before the Supreme Court, you have to know your stuff. You have to know the case really well. You have to know the precedents extremely well, because they could ask you about any part of it. And you may walk into oral argument wanting to focus on one particular topic, but that may not be what's on the justice's mind. And so they may ask you about other things that you really didn't want to talk about, but of course you have to answer the questions that they ask. Now, this is a very intense 30 minutes. It's very nerve-wracking, but it's not all bad necessarily. Certainly, many of the questions that are directed at you might be hostile. Some of the justices may not particularly care for the legal position that you're arguing, and they may ask questions designed to undermine you. But there might be justices out there who are more sympathetic, and sometimes justices will be helpful. If you've forgotten the name of a precedent or you need other assistance, they may help you out, or they may help ask you a softball question. And so there is this interesting give and take, and you never know exactly what you're going to get when you walk into that courtroom. One thing, though, it is considered bad form to read directly from your notes. You probably never like that when somebody does it in a class at an oral presentation. They really don't like it in the Supreme Court, reading directly from your notes for the most part indicates that you're probably not as familiar with the case, and your quality of advocacy is probably not quite as high as the Supreme Court would like to see. On that point, I'd just like to share with you a very brief snippet of oral argument in the case of Marvin Brandt Revocable Trust v. U.S. This is not a famous case. The case itself isn't important, but right at the beginning of oral argument, as you will hear, Justice Scalia calls out one of the attorneys in the case for reading from his notes. And you can tell it throws him. There's a long pause, and looks like things are going off the rails, but then fortunately Justice Stephen Breyer steps in and helps save the day with some comforting words. So here's an example of why you should never read from your notes when appearing before the Supreme Court.
When the government issues a patent, it divests itself of title, except for those interests expressly reserved. Here, the patent did not reserve any interest in the 1875 Act.
Yeah, so you're not reading this, are you? That's all right.
Now, most justices ask quite a number of questions during oral argument. If you are arguing in front of the court, you can expect that most of the justices will ask you a question at one point or another. However, one justice is a notable exception, and that is Justice Clarence Thomas. Justice Clarence Thomas is well known for asking virtually no questions at oral argument. In fact, Justice Thomas says that he would eliminate oral argument altogether. He considers it to be a waste of time. He says that I think that when somebody's talking, somebody else ought to listen, or somebody ought to listen. Now, I guess that's a good sentiment, but of course that isn't the purpose of oral argument. In any case, just to show you how rarely he speaks, back in January 2013, he spoke for the first time in 7 years. And it made national news. Literally, it had been so long since he'd spoken that it was in the New York Times and other news outlets, and he made a joke from the bench. He has spoken a couple of times since then, so I guess maybe he's getting a little bit more talkative, but seriously, he can go for years at a time without ever asking a question. So, who's the funniest justice? Well, he's no longer with us, but when he was on the bench, Antonin Scalia was the funniest justice. Political scientists did a study, and if you take a look at the transcripts of Supreme Court oral arguments, when there's laughter in the courtroom, it's noted in the transcript, and Scalia got more laughs than any other justice. So, what are the purposes of these questions? Well, it's interesting because it is possible for oral argument to change minds, although one justice once said that they never saw a case won at oral argument, but they saw lots of cases lost at oral argument, meaning some attorneys gave such bad presentations that they blew it for their side. But nevertheless, the court does believe that oral argument is important, and so the purposes of these questions are because the justices are in an interesting position. They're deciding a legal case between two individual parties, but they're not just deciding the disputes between those two parties, but they're going to be establishing general legal principles known as precedent that the court has to use and lower courts have to use in later cases. So out of a specific dispute is going to come a very general principle that's going to be used in the future. And so what they often want to know when they're asking these questions is how the legal principle that the attorney is arguing would apply in other circumstances. And so, as a result, a lot of times when you listen to oral argument, lots of the questions are hypothetical questions. Where they say, Counselor, what would happen then if this occurred? Or how would your legal argument work in this other situation? Now, these, of course, are not things that are actually happening now, but the justices are worried about the future effect of their possible decisions. And, of course, so they not only look forward to find out what the future applicability of what they might decide might be, but, of course, they have to look to the past because they do decide their cases based on precedent or prior cases, and so there is also a lot of discussion about the applicability of prior cases to the present case. Now, what I'd like to do is have you listen to just about 3 minutes of oral argument from Hollingsworth v. Perry, and this, if you'll recall, is the Proposition 8 case that we talked about in class earlier in the semester. And if you'll recall, although this case was about gay marriage, it also involved the issue of standing because the governor and attorney general of the state of California refused to defend Proposition 8 in court. And so as you listen to this oral argument, listen to the give and take, and listen particularly to the fact that right at the beginning the attorney makes clear that he wants to talk about gay marriage, but right away Justice Roberts changes the subject on him and starts to talk about standing. Notice also that many of the justices talk just in this 3-minute segment. So just take a listen. You don't have to get bogged down in the details. We're just listening so you get a little flavor of what oral argument is actually like.
We'll hear argument this morning in Case 12-144, Hollingsworth versus Perry. Mr. Cooper?
Thank you, Mr. Chief Justice, and may it please the Court. New York's highest court, in a case similar to this one, remarked that until quite recently, it was an accepted truth for almost everyone who ever lived in any society in which marriage existed.
Mr. Cooper, we have the jurisdictional and merits issues here. Maybe it'd be best if you could begin with the standing issue.
I'd be happy to, Mr. Chief Justice. Your Honor, the official proponents of Proposition 8, the initiative, have standing to defend that measure before this Court as representatives of the people and the state of California, to defend the validity of the measure that they brought forward.
Have we ever granted standing to proponents of ballot initiatives?
No, Your Honor. The Court has not done that, but the Court has never had before it a clear expression from a unanimous state's high court.
Well, this is the concern is certainly the proponents are interested in getting it on the ballot and seeing that all the proper procedures are followed. But once it's passed, they have no proprietary interest in it. It's law for them, just as it is for everyone else. So how are they distinguishable from the California citizenry in general?
They're distinguishable, Your Honor, because the Constitution of the State of California and its election code provide, according to the unanimous interpretation of the California Supreme Court, that the official proponents, in addition to the other official responsibilities and authorities that they have in the initiative process, that those official proponents also have the authority and the responsibility to defend the validity of that initiative.
I guess the Attorney General of the state doesn't have any proprietary interest either, does he?
No, Your Honor.
But he can defend it, can't he?
Nor did...
Because the law says he can defend it.
That's right, Your Honor. Nor did the legislative leaders in the Karcher case have any particular enforcement.
Could the state assign to any citizen the right to defend a judgment of this kind?
Justice Kagan, that would be a very tough question. It's by no means the question before the Court, because it isn't any citizen. It is the official proponents that have a specific and carefully detailed.
Well, if you would, on the hypothetical, could a state just assign to anybody the ability to do this?
Your Honor, I think it very well might. It very well might be able to decide that any citizen could step forward and represent the interests of the state and the people in defending.
That would be. I'm sorry, you finished?
Yes, Your Honor.
Okay. That may be true in terms of who they want to represent, but a state can't authorize anyone to proceed in federal court, because that would leave the definition under Article 3 of the federal Constitution as to who has standing to bring claims up to each state. And I don't think we've ever allowed anything like that.
But Your Honor, I guess the point I want to make is that there's no question that the state has standing. The state itself has standing to represent its own interests in the validity of its own enactments. And if the state's public officials decline to do that, it is within the state's authority, surely, I would submit, to identify, if not all, any citizen or at least supporter of the measure, certainly those that very clear and identifiable group of citizens who are...
The Chief Justice and Justice Kagan have given a proper hypothetical to test your theory, but in this case, the proponents, number one, must give their official address, they must pay money, and they must all act in unison under California law. So these 5 proponents were required at all times to act in unison. So that distinguishes and to register and to pay money for the so in that sense it's different from simply saying any citizen.
But of course it is, and I think the key...
But can you tell me, that's a factual background with respect to their right to put the ballot initiative on the ballot. But how does it create an injury to them separate from that of every other taxpayer to have laws enforced?
Your Honor, the question before the court I would submit is not the injury to the individual proponents. It's the injury to the state. The legislators in the Karcher case had no individual particularized injury.
So what's it like to engage in oral argument? Well, we're going to watch a little bit of an interview from John Roberts where he talks about that because he argued cases before the Supreme Court before he became a justice. And in this interview, notice how he discusses the need for candor and honesty and being forthcoming. So this is not really a political event, but rather he tries to suggest a search for the truth. Whether that's accurate or not is up to you to decide, but let's take a listen to see his insights on what it's like to be an attorney arguing before the court.
Do you remember your first oral argument?
Oh, sure. Yes, absolutely. A case called United States against Halper. I was very nervous, but I was very nervous when I did my last oral argument as well. I think if you're a lawyer appearing before the Supreme Court and you're not very nervous, you don't really understand what's going on.
This is a question for all the members of the bar out there, I guess, and for all those attorneys who eventually find themselves lucky enough to have a case before the court. What is it that you wish you had known about the process when you were on that side that you now know?
Everybody tells a lawyer in that position, you have to answer the questions. Don't try to avoid the questions or distinguish your case in any way. I hope I did that when I was a lawyer, but the importance of that is very accentuated. I appreciate it so much more now that I'm on the other side of the bench. You have to appreciate that the justices are engaged in the process of trying to help themselves decide the case correctly. So they're going to ask hard questions. They're going to ask questions that don't put your case in the best possible light, and you need to appreciate that. It's good to establish, and I think I didn't appreciate this as much as I should have, some dispassion. Yes, you want to have a certain level of zeal and commitment to your client's cause. The justices know that. But when they ask you a question about a difficult case, it's better to sometimes say, I appreciate that case doesn't support my side. I appreciate that causes us some difficulty. Here's why I think you shouldn't rely so heavily on that case, as opposed to as soon as they ask us, no, that case doesn't hurt us at all, and here's why. They like you to be part of the process that is helping them come to the right result. They understand you've got a client to represent, and they expect you to do that. But if you can convince them that you're on their side in helping them reach the right decision, as opposed to something they have to push against to get you to give an answer, I think that's very helpful, not only to the court but also to your client.
Because oral argument is the only public thing that the Supreme Court does, there is intense public scrutiny of the justices' questions and comments. people attempt to read the tea leaves to see if they can try to predict the way the justices will ultimately decide the case based on the comments and the questions that they have during oral argument. Sometimes, of course, these are successful and sometimes they're not. And that's simply because the justices' motives for asking questions are complex. Maybe they're thinking about a theory you've never thought of before. Justice Scalia said that sometimes he liked to ask questions just to confuse people that were trying to predict what the court would do. So, you try to do this at your peril. I remember one particularly famous case was back in the 1990s. The Supreme Court decided a case of whether topless dancing in Indiana was protected by the First Amendment. In the state of Indiana made it illegal to engage in topless dancing, and some individuals sued, claiming this violated the free speech clause of the First Amendment. Playboy magazine, which normally doesn't take much interest in Supreme Court decisions, sent a reporter, and they predicted from the questions that the court was going to strike down that law, but they were wrong. The court upheld it. So why does the court hold oral argument? Justice Thomas says they should just get rid of it. Well, oral argument does have some very important functions. And of course, at the very top of that list is symbolism. And symbolism, of course, is very important to almost everything the court does. They want to convince you that they are a legal, not a political institution, and oral argument helps persuade you that the court actually considered the case carefully, that they didn't just close their mind, that they didn't just toss a coin, that they really thought about it. And this really can help clarify issues. You've got a very long brief, it's filled with a lot of stuff. In 30 minutes, you've got to really sort of focus on those things that are most important, and oral argument can help the justices do that. As I mentioned, they can talk to each other. An oral argument begins the process of communication between the justices. Ultimately, the justices are going to be working together to arrive at a decision, and there's going to be a fair amount of communication between them, and the process begins in the courtroom, or it can begin in the courtroom. And of course, hopefully, oral arguments can be persuasive as well. Of course, on many issues, on abortion or affirmative action, the justices probably already have their minds made up. But on other cases that aren't so ideological, certainly some minds are changed by effective advocacy in the courtroom. Well, that's all we have to say for now about oral argument. After the case is done, the justices go back into conference for the process of writing the opinions, and we will talk about that in our next lecture.